All right, let's talk about something that is absolutely critical for every single nurse out there: legal responsibilities. And look, this isn't just some boring topic you have to cram for your exams. No, this is about real-world stuff, protecting your patients, your license, and honestly, your own peace of mind. So, let's get right into it.
So let me kick things off with a classic scenario, one that trips up so many students. Picture this. You've got a really difficult patient, and a staff member threatens them with a feeding tube. Is that assault or is it battery? By the time we're done here, you'll not only know the answer cold, but you'll get why it's the right answer. Plus, a whole lot more.
Okay, so here's our roadmap for today. We're going to start with the legal framework, then get into the 3 categories of torts. After that, we'll dissect professional negligence, champion your patient's rights, cover your core responsibilities, and then wrap it all up with some NCLEX prep and clinical judgment practice. Pretty straightforward, right? Let's do it.
All right, first up, the legal framework of nursing. To actually follow the rules, you've got to know where they come from in the first place. This is really the bedrock of safe practice for your patients and for you.
So when you think about the laws that govern nursing, they really come from a few main places. You've got your big, overarching federal regulations. Think HIPAA, stuff that applies everywhere. Then it gets more local with state laws, which can be super specific depending on where you practice. And finally, you have these 2 huge buckets, civil and criminal law. And that's all about how legal issues actually get sorted out.
Let's make this super clear. Criminal law is the big stuff. It's when you've done something that's considered a crime against society, and the government itself comes after you. A really serious example would be intentionally falsifying a medical record to hide a major error. Civil law, on the other hand, is usually between people or organizations. It's about protecting individual rights. And this is where most nursing legal issues live, under something called tort law.
Okay, if there's one thing you really need to drill into your head, it's this. Your state's Nurse Practice Act is your Bible. Seriously, federal laws give you the basics, but this document, this is the rulebook that tells you exactly what you can and cannot do in your state. The State Board of Nursing enforces it, and you absolutely have to know it inside and out.
Okay, on to our next section, torts. That word might sound a little weird, but all it means is a wrongful act that messes with someone's rights and could end up in a civil lawsuit. And trust me, for nurses, this is a huge deal. So torts basically come in 3 flavors. First, you've got your unintentional torts. This is stuff like negligence, where you didn't mean to hurt anyone, but you messed up and harm occurred. Then there's this middle category called quasi-intentional. Think breach of confidentiality. You meant to share the info, but you probably didn't mean for it to cause all the resulting drama. And last, you have intentional torts. This is when you absolutely 100% meant to do the thing, like threatening a patient.
And hey, this brings us right back to that question I asked at the beginning. So what's the difference between assault and battery? It's simple, really. Assault is the threat. It's making someone afraid that you're about to do something. So threatening to place an NG tube, that's assault. Battery is the actual wrongful physical touch. Actually giving an injection when the patient said no, that's battery. Just remember, threat versus touch.
Okay, NCLEX tip time. Let's test this. An assistive personnel tells a client, hey, if you use that urinal improperly again, you're going into diapers. Is that assault, battery, or false imprisonment? What do you think? It's A, assault. Why? Because it's a threat. They're making the client afraid of what will happen. Nothing has physically happened yet, but that verbal threat is the assault.
All right, section 3. We're diving deep into the big one, the legal issue you'll hear about most often, professional negligence. You probably know it by its other name, malpractice. So for a patient to actually prove malpractice, their lawyer has to check off 5 specific boxes, all 5. If even one is missing, the case falls apart. And to help you remember these 5 elements, I've got a great little memory anchor for you. Just think, do, be, forever, careful, and honest. That stands for duty, breach, foreseeability, causation, and harm. Let's make this real with a fall risk scenario. Okay, number 1, duty. You have a duty to complete a fall risk assessment on your patient. Simple enough. Number 2, breach. You get busy, you forget, you just don't do the assessment. That's a breach of duty. 3, foreseeability. Should you have known that failing to do this could cause harm? Absolutely. It's foreseeable that a high-risk patient could fall. 4, causation. Because you didn't do the assessment, no fall precautions were put in place. Your breach led directly to that lack of safety measures. And finally, number 5, harm. The patient falls and fractures their hip. Boom, all 5 elements are there. That's how a malpractice claim is built.
Okay, let's shift gears a little bit for this next section. We've talked a lot about what can go wrong, but understanding the law is also about being a fierce advocate for your patient. It's not just about covering your own butt. It's about championing their rights.
And at the heart of patient rights is this concept of informed consent. And please, please hear me on this. It is not just about getting a signature on a piece of paper. It is a whole legal process that makes sure the patient truly understands what's happening to their body so they can make their own decision.
So who does what? It's pretty clear-cut. The provider, the doctor, the surgeon, their job is to obtain the consent. They do the explaining. The client's job is to listen and give the consent voluntarily. And what's your job as the nurse? Your job is to witness that signature. But more than that, you're the final safety check. You're there to confirm, hey, did you really understand everything the doctor said? You are that patient's last line of defense.
And this idea of patient autonomy goes even further. Every competent adult has the right to say, no thank you, and walk right out of the hospital, even if it's against medical advice, or AMA. Now, your job is not to physically block the door. Your job is to make sure they understand the risks of leaving, to notify the provider immediately, and to document every single thing that happened.
Okay, moving on. Your legal responsibilities go way beyond just direct patient care. Let's talk about some other core duties that are a huge part of being a professional nurse.
So you've got things like advance directives. That's the living wills and powers of attorney that let people decide their end-of-life care ahead of time. And then there's mandatory reporting, which is a big one. You are legally required to report suspected abuse of a child or an older adult. Same goes for certain communicable diseases. And this can be a tough one. You also have a duty to report a coworker if you think they're impaired. It's all about protecting people who can't protect themselves.
All right, last section. Let's pull all of this together and see how it looks in the real world. We're going to connect all these legal ideas to some NCLEX prep and clinical judgment scenarios you'll actually face.
Okay, practice question time. A client is working on their advanced directives and says, I'm going to make it clear I don't want to be kept on a breathing machine. Does this show they understand the purpose of a durable power of attorney, a living will, or a DNR order? The answer is B, a living will. A living will is a document about your wishes for treatment. A durable power of attorney is about who makes the decisions for you if you can't. See the difference? It's wishes versus the person.
Okay, everyone's favorite, a select all that apply. When you're witnessing informed consent, what are your primary duties? Is it A, making sure the client gets it, B, talking about other treatment options, C, witnessing the signature, or D, telling the provider if the client still has questions? Pick all that apply. The right answers are A, C, and D. Your job is to ensure understanding, watch them sign, and get the provider if they're confused. What's not your job? B, discussing alternatives is the provider's territory. Know your lane.
All right, let's finish up with a classic NGN case scenario to really get you thinking. Imagine this. You're at the end of a long night shift, you're giving report to the oncoming nurse, and you notice they smell like alcohol. They seem a little unsteady on their feet. Right away, every alarm bell in your head should be going off. You have a legal and an ethical duty to do something.
So, what's your next move? What is the very first and most appropriate action you need to take in that exact moment? I'm going to leave you with that to think about. Consider everything we've talked about: patient safety, your legal duty to report, the chain of command. Because figuring out that next step, well, that's what clinical judgment is all about. Thanks for sticking with me today.